You were charged of driving while intoxicated. Second offense. You were facing up to a year in jail and or a $4,000 fine. You know,
Welcome back to another intense day in the courtroom where real consequences meet real people. Today we got two cases that will absolutely blow your mind. First up, a second offense DWI where the judge delivers one of the most powerful warnings about drunk driving you'll ever hear. We're talking about a 31-year-old facing serious time, and the judge is not holding back. She's dropping truth bombs about construction workers killed by drunk drivers, the ease of calling an Uber, and what happens when you turn mistake into a felony. Then we're diving into a terroristic threat case that's straight out of a nightmare. 23 phone calls in one day, threats to shoot someone in the legs, so they can't work, wheelchairs left outside homes as intimidation tactics, and a GPS monitor being slapped on an ankle. This is courtroom drama at its absolute peak, with a judge who genuinely cares about keeping her community safe. Buckle up, because these cases are about to get real.
you just heard what I said to this other gentleman here. Life doesn't get easier. It gets a lot more difficult the older you get. And when you start racking up convictions, all you're doing is you're making the life even just more difficult. If you have a drug and alcohol problem, there are ways to address it. But when you endanger other people's lives, you may end up digging a hole that's so deep you'll never crawl your ass out of it. And you'll be stuck like Chuck in custody for the next 40 years. It happens time and again. If you don't believe me, watch the news. Every single day, someone dies from a DWI in our county. Yesterday, a construction worker. Take an Uber. It's extremely easy. They make it so easy that all you literally have to do is push one button. Because I'm going to tell you now, with your history, if you ever get pulled over and an officer smells anything funky, you're going to go down. And this time, it's out of my hands. From now on, you're in felony court. You're 2 to 10 at the penitentiary. Even the faintest smell of alcohol. Do you understand, Mr. Jaggers?
Yes, sir.
Stop right there, because what we just witnessed is one of the most powerful and brutally honest warnings a judge can give. This defendant is facing his second DWI offense, and the judge is laying out exactly what his future looks like if he doesn't get his act together. Let's break down what she just said. First, she's making it crystal clear that life only gets harder as you get older, especially when you're stacking up criminal convictions. Each conviction makes everything more difficult. Getting a job, housing, loans, everything. Then she drops a devastating fact. Just yesterday, a construction worker in their county was killed by a drunk driver. Think about that. Someone went to work, probably had a family waiting for them at home, and never made it back because someone decided to drive drunk. The judge is emphasizing that calling an Uber literally takes one button push. There's absolutely no excuse. But here's the critical part. This is his second DWI offense. The judge warns him that if he gets pulled over again and an officer smells even the faintest hint of alcohol, he's going straight to felony court. We're talking 2 to 10 years in the penitentiary. That's not a slap on the wrist. That's serious prison time. At just 31 years old, he could be facing decades behind bars if he doesn't change his ways. The judge is trying to prevent him from digging a hole, so deep he'll never climb out. Do you think second-time DWI offenders deserve this level of warning, or should the penalties be even harsher? Let me know in the comments.
Somehow we have to get through to you. Hopefully it doesn't take the fact that you sit there charged with a 5-to-life case because you've done something that just get a clue. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, these will go on your record. 1 and 1 are 2. 2 plus 1 is 3. A third, you're looking at 2 to 10 at the penitentiary. Do you understand?
Sir.
The rest of your life. What are you, 32 right now?
31.
31. You're going to be driving for the next 40 years. How do you plead to the offense of second offense driving while intoxicated? I'm going to find you guilty. I'm going to sentence you to 330 days in jail. I'll give you credit for the 113 days that you've done. I am going to suspend your license for 1 year. Do not drive until you get a license.
Okay, let's talk about what just happened here, because this is a masterclass in judicial responsibility. The judge just explained the math of criminal convictions in the simplest terms possible. 1 DWI plus 1 DWI equals 2. And if there's a third, you're looking at 2 to 10 years in the penitentiary. That's the harsh reality of how Texas handles repeat DWI offenders. The judge then goes through the formal plea process, making sure the defendant understands all the rights he's giving up by pleading guilty. The right to trial, to confront witnesses, to appeal. And she specifically mentions immigration consequences, warning that non-citizens can be deported for DWI convictions. Now here's the sentence. 330 days in jail, but he's getting credit for the 113 days he's already served, which means he's got about 217 days left. That's roughly 7 more months behind bars. Plus, his license is suspended for a full year, meaning he can't legally drive at all until he gets it reinstated. The judge emphasizes that he'll be driving for the next 40 years of his life. So why risk throwing all away? But here's what makes this case interesting. Despite the serious sentence, there's going to be some leniency coming up. The judge is clearly trying to balance punishment with rehabilitation, giving him a chance to turn his life around. The question is, will he take it? What do you think? Is 330 days too harsh, too lenient, or just right for a second DWI? Drop your thoughts below.
What do you do for a living, Mr. Jaggers? How much money do you make a month?
0 right now.
I'm appointed to this case, Judge.
So you're working for free? What?
Yes.
I don't know. Well, why would we reward him? He was to obtain a device he just never did.
He doesn't have a vehicle, Your Honor. I was notified by pretrial yesterday that there was this BVR. Talked to Mr. Jaggers about it. He didn't have a vehicle, and by his account, that didn't have a vehicle. He didn't know what to do. But he's here today.
So you just do whatever you want? I mean, this continue to happen over and over and over. I mean,
He spent, better part of 4 months, 3 months in jail, awaiting resolution of this case. He has done that time, Your Honor. He's working now. I really believe that to help him get better, he needs to put this behind him and get started with a new phase of his life.
Mr. Jaggers, I'm going to waive the court costs and I'll waive the DPS fine and surcharge. Just take a damn Uber, man. It's not hard. One button on your phone. All this could be avoided by hitting one button on your phone. All right. Good luck.
Thank you, Judge.
Okay.
Here's where the case takes an unexpected turn. And honestly, this shows the compassionate side of the justice system. The prosecutor was initially pushing back, questioning why they should reward the defendant since he was supposed to get an ignition interlock device installed in his vehicle, but never did. That a valid concern. He failed to comply with a court order. But then the defense attorney makes a compelling argument. The defendant didn't have a vehicle, so how could he install the device? He spent nearly 4 months in jail waiting for this case to resolve, and now he's working and trying to rebuild his life. The defense attorney argues that to truly help him move forward, he needs to put this case behind him and start fresh. And you know what? The judge agrees. Despite the serious nature of a second DWI offense, she decides to waive the court costs and the DWI fine, giving him a clean slate financially. But she doesn't let him off without one final reminder. Just take a damn Uber, man. It's not hard. One button on your phone. She's emphasizing that all of this, the jail time, the suspended license, the criminal record, the court costs, could have been completely avoided by simply pressing one button on his phone to call a ride. This is a perfect example of how judges have discretion to show mercy when they believe a defendant is genuinely trying to turn their life around. The defendant served his time. He's working now, and the judge is giving him a real second chance. Do you think this was a right call, Or should there be zero tolerance for repeat DWI offenders? Let me know what you think.
Carlos Barrera. Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On September 11th, 2024, in Harris County, Texas, an officer met with the complainant who advised that in the morning he received multiple phone calls from an unknown number beginning at 4:30 a.m., lasting through 4:50 a.m., in which the defendant called a total of 5 times. The complainant stated he did not answer the phone from previous knowledge that it was the defendant calling him to confront him. The complainant stated he left to work, and when he returned at approximately 4 p.m., he noticed multiple phone calls from an app-generated phone number that called him a total of 18 times. The complainant stated that on the 18th call, he answered the phone and let the defendant talk. The complainant was able to get a second cell phone and record the defendant, stating, "I know where you stay at. You don't know where I am." The complainant stated he had sent a text message to the phone number that the defendant kept calling from, and said that he did not wish to have any contact with him and to leave the complainant alone and stop calling. The complainant stated that during the conversation over the phone with the defendant, before he was able to record the phone call, the defendant stated he was going to shoot the complainant in the legs so he could not work as an electrician. The complainant stated that the defendant is the complainant's current girlfriend's ex-boyfriend. The defendant is the complainant's current girlfriend's ex-boyfriend. The complainant told the officer that he believes the defendant is capable of carrying out his threat and the complainant is in fear for his life.
Okay, hold everything, because this case just escalated from 0 to absolutely terrifying in about 2 minutes flat. Let me break down what we're dealing with here. This defendant made a total of 23 phone calls in a single day to the victim, 5 calls starting at 4:30 in the morning. Then 18 more calls later that same day using an app-generated phone number to hide his identity. The victim knew it was a defendant calling to confront him, so he didn't answer. But on the 18th call, he finally picked up and had the smart idea to record the conversation on a second phone. And what did the defendant say? Quote, "I know where you stay at. You don't know where I am." That right there's a direct threat, but it gets worse. Before the victim could start recording, the defendant allegedly threatened to shoot him in the legs, specifically, so he couldn't work as an electrician. Think about how calculated that is. Not just threatening to kill him, but threatening to disable him permanently so he can't earn a living. And here's the twisted relationship dynamic. The defendant is the ex-boyfriend of the victim's current girlfriend. This is a classic case of someone who can't let go and is now making violent threats against a person who's moved on. The victim explicitly told officers he believes the defendant is capable of carrying out these threats and that he's genuinely in fear for his life. That statement is crucial because it establishes the victim's state of mind and shows this isn't just empty talk. It's credible intimidation. What do you think should happen in cases like this? Should stalking and terroristic threats carry harsher penalties? Let me know in the comments.
All right, Mr. Barrera, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with this person. Do you understand? I'm also ordering you not to be in possession of any weapons. If I find that you violate any of these conditions, if you are a danger to my community, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
And Judge, given my conversation with the complainant that I had yesterday, the state would request a GPS monitor because he has continually gone to the residence since this incident and has made threatening comments towards the mother-in-law as well. And recently, as of a couple of days ago, I guess he left his wheelchair outside the home in order to make some sort of threat that he's been going near the residence.
So the threats are still continuing?
Yes.
Sir, I'm now putting a monitor on your ankle so I know that you're not going over there. You're not to go within 1,000 feet of where they live or where they work. Do you understand?
This is where the judge takes decisive action to protect the victim. And honestly, this is exactly what needs to happen in stalking and threat cases. The judge immediately finds probable cause and sets strict bond conditions. No contact with the victim, no weapons, and a clear warning that if he violates any conditions or becomes a danger to the community, his bond will be revoked immediately. But then the prosecutor drops even more alarming information. Apparently, this defendant has been continuously going to victims' residence even after being charged, making threatening comments to the victim's mother-in-law. And get this, he left his wheelchair outside the home as some kind of intimidation tactic. That's next-level psychological warfare. The threats aren't stopping, they're escalating. So the prosecutor requests a GPS monitor, and the judge grants it immediately. Now this defendant is going to have an ankle monitor tracking his every move, and he's prohibited from going within 1,000 feet of where the victim lives or works. That's serious enforcement. GPS monitoring isn't cheap, and it's not comfortable, but it's absolutely necessary in cases like this where someone has demonstrated they can't or won't respect boundaries. The judge is making it crystal clear. If he goes anywhere near that residence or workplace, she'll know about it instantly, and he'll be right back in jail. This is proactive justice, stopping a dangerous situation before it becomes a tragedy. Do you think GPS monitoring should be mandatory in all stalking and threat cases? Share your thoughts below.
Hold on. I don't want you to say anything. I will give you a lawyer today. You can talk to the lawyer, but understand my only concern is community safety. That's all I care about in this life. You know, we take things step by step. Let me do this. I'm going to give you a lawyer. I'll let you talk to the lawyer. I got a bunch of DAs here. Whatever you say, they're going to use it against you. Let me give you a lawyer. We'll go from there. But don't go where they live. Don't go where they work. Don't accidentally bump into them. Do you understand? So for now, I am going to put a GPS monitor, and so we know where you are. And you're not to go anywhere where they live or work. I'm going to have you now sign a receipt of Victoria. After that, we'll just have you wait for the lawyer that we get, and we'll go from there. Do not leave until you sign our bond conditions. Otherwise, I'm going to revoke your bond. Okay. Felicia, it'll be with you because you're monitoring. And wait, defeat. The deal is this, is that life is way too short. Life is way too short to make a decision where you make it, or you've dug yourself a hole so deep that you'll never get out of. There are plenty of other fish in the sea, and it's time at times to just move on. Cut your losses, move on, because life's just way too short, you know? There are other people out there, and as long as I know that we don't have any more issues in the future, I'm willing to take it off. But at this point, I got to know that it's going to stop, right? I'm not going to take your word for it that it's just going to stop. I need more than that. So that's why I put this monitor on you. After some time, if I know that I can trust you, then perhaps we can amend the conditions to take it off. But at this point, all I have is that you've picked up a criminal case. They're alleging that it's continuing to happen, and I want it to stop. Not I want it. It's going to stop one way or the other. I told you, life is too short. Move on. That's all that needs to happen. Do you understand?
But you know that got shot.
Okay. So you've got a lawyer, right? My only concern is that you don't have any contact with these people and you don't go where they work. The past, I get it, it's the past. I get that you guys have bad blood. All I want to do is I want to prevent further bloodshed. I don't want any more bad blood. That's all I'm asking. I'm not asking for something unreasonable. But what we can do, after some time, I'll have them reach out, and if there are no issues, I can take it off. Do you understand? All right. I'm not asking for much. Just move on. You know, it's just like I said, people here in life, in the jail, are there because they have no self-control. They just wig out, they do stuff without thinking, and then they make some kind of decision where they're looking at 40 to 50 years. Don't. It's not worth it, you know? Okay. All right. So after some time, come back. Good. We'll take it off.
And that wraps up another powerful session in the courtroom that really makes you think about choices, consequences, and second chances. Let's recap what we just witnessed today. In our first case, we saw a 31-year-old defendant facing his second DWI offense. The judge delivered one of the most passionate and honest warnings I've ever heard about drunk driving, reminding him that just yesterday a construction worker was killed by a drunk driver in their county. She emphasized that calling an Uber takes literally one button push, and warned him that if he gets caught again with even the faintest smell of alcohol, he's looking at 2 to 10 years in the penitentiary. Despite sentencing him to 330 days in jail, the judge showed mercy by waiving court costs and fines, giving him a real chance to rebuild his life. Then we moved to an absolutely chilling terroristic threat case involving 23 phone calls in one day, threats to shoot the victim in the legs, so he couldn't work, and continued stalking behavior, including leaving a wheelchair outside the victim's home as intimidation. The judge didn't hesitate. She slapped a GPS monitor on the defendant's ankle and prohibited him from going within 1,000 feet of where the victim lives or works. But what really stood out was the judge's life advice. Life is way too short to dig yourself a hole so deep you'll never get out. There are plenty of other fish in the sea. Move on. She's trying to prevent bloodshed before it happens, recognizing that people end up in jail because they lose self-control and make split-second decisions that cost them 40 to 50 years of their lives. These cases show the balance judges must strike between punishment, protection, and rehabilitation. If you found these cases as compelling as we did, make sure to smash that like button. Share your thoughts in the comments about which case impacted you the most. And don't forget to subscribe for more incredible courtroom breakdowns that show real justice in action. We'll see you in the next one.